right, Madam Clerk, would you call the next case, please?
State of Tennessee versus Jeffry, Tate, and Stephen Ogle.
Good morning again, Your Honors. Alan Groves on behalf of the state. I'd like to reserve 5 minutes for rebuttal.
All right, General Groves.
This is a consolidated appeal involving a constitutional challenge to the contractor fraud statute, which punishes new home construction contractors and home improvement service providers who, with the intent to defraud, fail to refund amounts paid under a contract when no substantial portion of the work has been performed after 90 days. The trial court granted the defendant's pretrial motion to dismiss the contractor fraud counts of the presentments after ruling that the statute is facially unconstitutional under the void for vagueness doctrine. This court should reverse because the vagueness challenges are both premature and meritless. First, I'll address why the trial court erred by addressing the facial vagueness challenges in this procedural posture. The parties agree that vagueness challenges outside the First Amendment context must be examined in light of the facts of the case at hand. In other words, the statute has to be judged on an as-applied basis. That principle dates back at least 50 years to the Hoffman Estates decision by the United States Supreme Court, and likely further. The Tennessee Supreme Court has also reiterated that principle in the State versus Burkhart decision, where it said that a party who engages in conduct that is clearly prescribed cannot complain of the vagueness of the law as applied to the conduct of others. And, Your Honors, this simply just makes sense. In the civil context, we require that parties have standing in order to bring a case, that they suffer an injury in fact. Similarly, in the criminal context, if you're challenging the constitutionality of a statute, here vagueness, in the vagueness context, you should have to show that the law is vague as applied to you before you complain about how the statute might hypothetically be applied to others. And I take it from the defendant's responsive brief that they agree on this critical legal principle. Your Honors, that should end this case because only one of the two defendants in this appeal actually brought an as-applied vagueness challenge. That would be Defendant Tate. The trial court, however, leapfrogged over that single as-applied challenge and declared the entire contractor fraud statute void for vagueness, facially void for vagueness. However, the court couldn't rule on the as-applied challenge at this stage of the proceedings for the reasons we've just said. I understand the defendant's position to be that the trial court, by declaring the statute facially unconstitutional, has simply implicitly ruled on Tate's as-applied challenge. But the court couldn't resolve an as-applied challenge before trial without the development of a factual record. So we've cited the State versus Sherman case where the Tennessee Supreme Court explains that for a Rule 12 motion, the trial court's limited to ruling on legal issues that are capable of determination before trial without submitting the case to the jury for the ultimate issue. Here, you can't evaluate an as-applied constitutional challenge without knowing the facts that would be applicable in this case. So here we didn't have any stipulations or concessions by the parties at the Rule 12 stage. We simply had an offer of proof that was purportedly made in Tate's Rule 12 motion to dismiss the presentment. However, as we all know, the allegations and the pleadings are not evidence. The state never stipulated to those facts, so that's not a proper basis for ruling on an as-applied challenge. I'll also direct the court to a couple of decisions that I think are helpful in thinking about this issue. One is State versus Welch from this court, where the court, in reciting the procedural history in a case involving an as-applied vagueness challenge, mentioned that the trial court had reserved ruling on a pretrial motion to dismiss the indictment on vagueness grounds until it had heard the state's case in chief, so that there was a factual record upon which it could make a ruling. We're submitting that's the proper procedure for the court to take here. Again, absent stipulations. If this goes back, the parties would be free to stipulate to certain facts if they would like to have the issue resolved before trial. Otherwise, we think the court should follow what the trial court did in Welch, which was to go to trial, have the states present its case in chief so that you have some facts to work with when you're evaluating the as-applied challenge. Another case, we cited several cases on this point from other jurisdictions as persuasive authority, and I just want to highlight one of those today, and that's the State versus Lewis case from the Connecticut Supreme Court. The court was actually considering a vagueness challenge, an as-applied vagueness challenge to Connecticut's Home Improvement Act, which is very similar to Tennessee's statute, if not identical in some respects. And there the court, again, held, just as we're arguing, that an as-applied vagueness challenge is simply premature before trial, absent stipulated facts, because the court can't evaluate the claim otherwise. And the court reversed the judgment and sent it back for further proceedings. So we think this court could easily resolve this appeal on this procedural basis alone, and we urge the court to do so. It doesn't need to reach the merits of the constitutional challenge.
Mr. Groves, when we look at the record, what notice did the trial court give to the parties, and did the notice involve, I guess, the court's expectations, where it was expecting a full mini trial of sorts? Are we going to find a fleshed out record as to that, how it got to the actually ruling on it, or is it just it decided on the facial challenge to the statute?
If I understand your question, Your Honor, both defendants filed Rule 12 motions to dismiss. So we just have pleadings at this point. Tate had an offer of proof where he made factual allegations in the motion, but there was no pretrial evidentiary hearing on the motions.
Was the state given an opportunity, I guess, to put on proof at a hearing?
There was a hearing, Your Honor, but the court just heard arguments of counsel, so there was no proof offered at the hearing.
Right.
But that could be done on remand if the parties would like to try to make some stipulations and get the issue resolved before trial.
But it's the state's position, that's why we have trials, to
Yes.
hear the facts.
Yes,
Okay.
especially for an as-applied constitutional challenge.
All right.
Is there any, I'm not sure why I think this, but is there any right for the Attorney General's office to come into this case to defend the Constitution, as opposed to the state AG? I mean, just to the local DA.
I'm not sure I understand your question, Your Honor.
Does the state, as far as the Attorney General's office, need to be a party to defend the statute?
So the state of Tennessee is the party to any prosecution, and our office is charged with defending the constitutionality of all state laws, both in civil cases and in criminal cases.
Do you do that directly or through the district attorneys?
So just by statute and under the Tennessee Constitution, the Attorney General's office represents the state in all criminal appeals. So the state is the
I'm talking about
party.
at the trial level. Is there any right of the state to come in through the Attorney General at the trial level and defend the constitutionality of the statute?
I understand your question now, Your Honor, speaking at the trial level. So there are statutes that talk about parties being required to notify the Attorney General's office if they're challenging the constitutionality of a statute at the trial court level. They're just supposed to provide a written notice. And that's a rule of civil procedure, I believe, that governs those cases. And in fact, the defendants, I believe, did actually file such a notice in this case pursuant to the rule of civil procedure. I think there's actually a little bit of a split of authority in this court as to whether the rules of civil procedure apply in criminal cases. The courts come out differently in those areas. That's not really an issue here because the defendants did provide that notice, but I don't think the rule or the corresponding statute contemplates the Attorney General's office appearing in court at the trial court level. So our role could be in the form of advising the district attorneys on how to proceed, but it's the district attorney's office that would be representing the state in the trial court proceedings. Sorry, I apologize for not understanding the question initially.
Well, it's just something I remember from a long time ago when I was a trial judge.
Yes, and I know the constitutional challenges don't come up all that frequently. But unless your honors have further questions about our procedural argument that the vagueness challenges are simply premature, I would like to spend a few minutes addressing the merits. And I'll begin by addressing the standard. So we've advocated that to succeed on a facial challenge, the defendants have to show the statute would be unconstitutionally vague in all its applications. Again, that goes back to the Hoffman case, and there's been an unbroken line of cases saying that's the standard for facial constitutional challenges. They rely on the Johnson decision, which was a case involving the Armed Career Criminal Act, to say that that's no longer the rule. And we dispute that. We think Johnson is fairly cabined to its facts because it involved the Armed Career Criminal Act and the sentence enhancement for prior violent felonies. If you had 3 violent felonies under that version of the statute that presented a serious potential risk of physical injury to another, the court held that that kind of a standard is facially vague and unconstitutional. However, the court clarified that there were 2 aspects of that statute that kind of conspired together to make it vague. One was the categorical approach, which required judges to think about the risk under an imagined, like, ordinary case of a crime, not necessarily real-world facts. And then combining that with the uncertainty about the level of risk, those 2 factors together made that statute vague. But we've cited the Second Circuit's decision in United States versus Rakena, which has explained that the best reading of Johnson is that it's cabined to the ACCA context. And until the Supreme Court clearly says that that's not the standard anymore for facial vagueness challenges or facial constitutional challenges, the court should continue applying the traditional standard. And on the merits, the defendants chiefly take aim at the word substantial in the statute because it says that it is not an offense if no substantial portion of the work has been performed. So a lot of the trial briefing in this case centered around the city of Knoxville case, where the court actually says that it's not casting doubt on the use of the word substantial or significant, which appears, as we know, in hundreds of state and federal criminal statutes. And just to give a few examples, Your Honors, our criminal attempt statute requires the state to show that the defendant took a substantial step toward the commission of the crime. The false imprisonment statute, or kidnapping, requires the state to prove beyond a reasonable doubt that the defendant substantially interfered with the other person's liberty. The word substantial is a common word of ordinary usage. It's something that juries are well equipped to understand. And especially in the context of this statute, it's clear that the word substantial simply means considerable in amount or value or extent. And that's going to obviously be fact-dependent. The state's going to have to put on proof about what stage of the construction we were in. We know at least 90 days would have had to have passed. But depending on what type of construction work we're talking about, what's involved, then the term substantial necessarily is going to be a little bit flexible. And the courts have routinely said that flexible standards like that are okay. They don't pose vagueness concerns ipso facto.
Can I ask you one other question?
Yes, Judge Montgomery.
How old is the statute in its present form?
The statute, I forget, Your Honor, when it was initially enacted. It's been on the books for quite a while, then it has been amended over the years to add various theories. I want to say the most recent amendment was in 2018, but I could be wrong.
I mean, have there been convictions that have been appealed that you're aware of?
So I'm aware of only 2 cases that have made their way up to the appellate stage. State versus Small, which affirmed a conviction for home improvement fraud. And it was under a different subsection of the statute for deviating from the plans rather than from failing to refund upon request. And then State versus Pardue, there was a reversal of a home improvement fraud conviction also from deviating from plans. And in that case, Your Honor, the court reversed based on the lack of intent. The state failed to have sufficient evidence of intent to defraud, which is the second reason we've argued why the statute is constitutional, because it has a mens rea requirement. And we think that's very significant. We've pointed the court to several cases where the court has rejected vagueness challenges based on like a knowing mens rea. Here, the intent to defraud is an even higher standard for the state to prove. So that is going to alleviate any vagueness concerns. And the defendants acknowledge that in their brief. They simply argue that for the rare person who has the fraudulent intent to defraud, that person still wouldn't understand whether they had performed a substantial portion of the work. If I'm understanding their argument the right way. But really, that turns the test on its head. The test is not, can we imagine some obscure example where someone would have the requisite intent but then still have the statute vague as applied to them. We look at would there be any set of circumstances under which this would be invalid. So I see that my time's about expired, so I'll reserve the remainder of my time for rebuttal.
Thank you, General Rhodes.
Thank you.
Counsel?
Thank you, Your Honor. May it please the court, my name is Richard Gaines, and I, along with Jeff Daniel and Mr. A.H. Bell, represent Mr. Tate and Mr. Ogle in this case. Not often I get to sit on that side of the courtroom. I have to disagree with the state. Let me try to sort of answer some of the questions the state has raised and questions the court has raised with the state, and then go into practicality for just a second. First off, we do not agree that we had to raise an as-applied argument initially. The Johnson case clearly does, I think, two things, holds the United States Supreme Court held, that not only can you go from the vagueness straight to facial vagueness, but it also sort of stands the proposition that you don't have to show that every application of the statute is vague in and of itself. I would argue in a minute that I think every application of the statute is vague as applied, but I'll skip that just for a second. So as a procedural matter, we think Johnson gets us past this. Now, to their point, the cases after Johnson in both federal and state courts have gone back and forth over whether those rules have been totally revoked from Johnson. But I don't really know if we need to get there, because what we have is a statute that is inherently and facially and obviously vague. And this court, or I'm sorry, the Tennessee Court of Appeals and the Tennessee Supreme Court have found this particular word in ordinances and statutes vague and unconstitutionally vague in two different cases. And one of them, City of Knoxville versus Entertainment Resources. And I didn't know it when the law clerk showed me the case, but I was actually one of the attorneys on that case. You know, you're getting older when that happens. And the other one's a 2005 case, the Boyle case, which we cited also. So we have two cases that have gone to the facial validity of the word substantial. I know there's an ordinance in one case, and I know it's a First Amendment issue, but we are talking about the freedom of people in a due process clause, and I don't really know if there's a distinction that can be made between those two. Let's take a look at something that was asked of the state a minute ago that I thought was a great question. Did we get notice, did attorneys, and this is not necessarily in the record, but did we get notice to do anything but argue the law? No, Judge Ogle got our motions and he said, I want to hear argument on the law. So we came in, and actually it's a fantastic back and forth between Judge Ogle and myself and the Assistant District Attorney General, Mr. Williams, about the argument about all these things that we say are vague and overbroad with regard to that part of the statute, which, to be perfectly clear, is 39-14-154B1, big B, little I. And that's the idea that a contractor has to have had a substantial portion of the project finished, and then there's not a crime. I could go to the intricacy of that statute. It is not well written. It starts off with 10 definitions. The definitions do not include a definition of the word substantial. But to answer your question, Your Honor, we did not get notice of any evidentiary hearing. We got notice of an argument only on the law. We did notice the state, prior to that hearing, Mr. Tate did, that we were contesting the constitutionality of the statute. I informed the state orally by phone. It's not in the record. And then we did also file something with the state on Judge Ogle's request. Make sure you file that with the state. Then he made a ruling that the statute was facially invalid based on the motion and the argument he heard, and I guess the logic of it too. Because the logic of it is, on its face, it is absolutely vague. I go back to the test for vagueness, and we think about, you know, getting to the merits before the procedure, and the state always wants to argue that we're out on waiver. Of course, the state AG's office wasn't present, and they were noticed that we were having a hearing on this. I'd love to be able to argue waiver to them for once, but in a criminal statute, to argue vagueness, really you have to first show that a person of reasonable intelligence can figure it out. No one could figure out in this context what substantial means. This is going to go back to why we're not wanting a remand in this case in a minute. But If a contractor was smart enough to get one of these letters and go talk to a lawyer, and he asked how much of the project has to be done that I can respond to the homeowner, he wouldn't know. You can't tell from the statute, it's not defined. A lawyer couldn't advise him on substantial. Substantial can be anything between 30 to 50 to 90% of a project. There's no way to advise a person of common intelligence, either reading the statute or, getting advice from a lawyer. I can see a sort of CLE for contractors in Nashville where a lawyer comes and advises them on the statute that says, and someone raises their hand, what's substantial portion mean? How are they going to be advised? They can't be. No one knows how much the project has to be done. If you remand this back, the proof is going to be our expert and whoever the state calls to show how much the project was done. How does that cure the problem? If we show 80% of the project was done, is that substantial? I'd argue it would be, but it might not be to a jury, and some people might think 90% is substantial. As a practical matter, we don't have any way to guide what we're doing. And as Judge Ogle pointed out, if I create a number, I'm legislating. I can't do that. And I said, well, if the state and us agreed to a number, we could waive the constitutional issue and go with a number like 70%. But we'd be legislating. What's happening is the lawyers and everybody would be legislating the definition of a word in a statute. That amounts to almost like an affirmative defense, really, right, in statute, because it puts the burden on us to show that we have to show a substantial portion of the project done. But we don't have any way to guide. When I first came to this case, I was asked by the lawyers, how do we guide our client into a defense in this case?
Well, what is your response to the state's argument of the use of the word substantial in other criminal statutes? They use criminal attempt and kidnapping.
Those are different, distinguishable, because those are parts of the elements of the offense. Those aren't think about it this way. When you say substantial to a project, you're talking about a percentage that's finished. Like how much in a house? Do you have the foundation? Do you have the beams up? Do you got electricity in? You can't determine that. Now, a substantial act towards kidnapping is something that can be more easily determined because it doesn't need to be an exact number. But for guidance of the men of common intelligence, for notice of a citizen contractor, he has no way to guide his behavior with that word. He has no way to say, wait a second, I've got this project almost done. It's different. And, beyond a reasonable doubt is kind of a vague thing to have juries define. And we can't define that as well either.
But under your scenario, the experts, either the contractor, defendant contractor, would get up on their own behalf and say X, and the state's expert would say Y. And those people would be involved in the trade and say that, this project was about 4 days away from completion and it's a 1-month project or something to that effect, and the jury could decide, right?
Yeah, the jury could decide. He could decide either way, though, right? I mean, it would be unclear. Well, think about what kind of burden that places on the defense, who's going to put an expert up that says it was 70% done and not having any idea whether that's substantial or not. I guess you could throw it to the jury with just a jury instruction that said the word substantial and let them try to work it through. We're probably going to get a good question in about an hour about that definition, right? But I don't think there's any way for them to understand what that means. I don't think there's any calculation. Some of the other cases that the word substantial has been used, they say substantial or over 5, or they put a number. Even the city of Knoxville, back in the Entertainment Resources, they had revoked that statute ordinance before the Supreme Court ruled, and had fixed it by putting a percentage down of some kind. It's that lack of percentage. And I'll tell you, Your Honor, one more thing as far as the standard goes on the due process challenge, the fact that it allows the law enforcement it doesn't give minimal guidelines on what restricts law enforcement discretion in this case. Now, we had that Entertainment Resources. I know because I recall the officers writing a ticket every day, but those are facts in the record in that case. In this case, we don't know who makes the decision, but there's an initial letter by the homeowner. And when the certified letter does not get answered or the money's not refunded, it can create something that they can take to the district attorney's office or the police. At that time, decisions are made about what substantial may mean because there's no response typically by a contractor. The breadth of what law enforcement can do extends all the way to the fact that what your question going to what a jury would do when they got an instruction that just used the word substantial. We have no way to predict that, no way to defend against that. We have no way to show in an affirmative defense what that means.
Well, under your scenario, though, let's say the General Assembly placed a number on it. Let's
Yeah.
say they said 50%, 51% is substantial.
Okay,
Okay?
sure.
All right. So the state would have the same factual pattern, perhaps with the extra proof of a contractor coming in, say, this project was only 40% completed, so it's not substantial. And it would place the defendant in the same situation, right?
Right. We would say maybe more was complete than the state would say. But that would go to the jury. They'd have 51%. And we'd say 65, and they'd say 40. Right now, we have no number, no bar. And if you create a number, it's legislative. What we want you to do is affirm Judge Ogle and let Nashville handle the statute and fix it. It needs fixing.
But if we didn't create a number, we would still be not legislating, right? If we rule for the state.
If you rule for the state and then just let it hang and let juries then get just the substantial instruction straight from the statute maybe, then that would create an inability for the common contractor to understand it, to guide his behavior, to defend him in court, and let a jury know what the heck substantial means, because it can mean anything to anybody. I mean, it can be anything from, I've had, let's see, this case has been going on a while. I've had probably 7 law clerks, and one of the first questions I ask them is, what do you think substantial means? And I've got a different answer. Even yesterday, we asked somebody, and they said 90% was substantial. It is all over the map. When it's that far all over the map, there's no guidance for us lawyers. There's no guidance for our client, the contractor, and all the contractors in the state of Tennessee to figure out how to avoid, I mean, the purpose of the statute, right, is to enforce behavior to be consistent with the law and not rip people off. Well, the contractors have to be able to figure it out, and they can't. And so it has to be vague. And that, by the way, even though I've argued that Johnson would say that almost every application would say that you don't have to do every application of the facts to show that it's vague, I don't think that's necessarily where we need to go. I think facially its application in every circumstance would have to be vague. Might be disagreement with the state on that, but every time a contractor would ask how to comply with this statute, you couldn't answer him. Every time he'd be in trial, you wouldn't know how to defend him. I don't know, Judge Ogle was convinced by the argument that he could not craft a jury instruction that would not be legislating and not be something he created for the jury. So, you know, we get to a point where we have something that's so vague that every one of the elements of a challenge on vagueness amounts to it can't stand as a constitutional statute. And there was another couple questions. Let me see if I can answer them. I think it was enacted in 2010, Your Honor. So it's a fairly recent statute. I sort of originally thought it was for the Gatlinburg wildfires, but it wasn't. It was a little older than that. Let's see. The state had the same notice we did. The state district attorney general didn't put any facts on either. We both argued just the law. I submit to this court, and again, I said a minute ago, if we went back, we would put our experts on, and each of the experts would then provide a percentage of the completion of the project, and we'd back in the same exact position we're in now. Because the state might argue that 40% is not substantial, and we might argue that 60% is, and we're at an impasse again. Even on a Rule 29, right, after all the proof in the state's case, we'd have a hard time understanding what the standard would be to be able to argue that. But we're forced to defend our client by coming up with an affirmative defense that says he made a substantial portion of the project complete. We're unable to do that. We're unable to tell our expert what he's supposed to be doing. So that's why that if you think we skipped a step, I believe Johnson helps us cover that. But that's also why that you can see the obvious nature of the invalidity, the facial invalidity, in the way this statute reads. And if you want to take a look at the statute, maybe you already have, it is a bit of a mess. It starts off with about 10 definitions, not including substantial in the definitions. Then it has the prohibition at B. It is an offense for a new home construction contractor or home improvement services provider with the intent to defraud. If you notice, the legislative history, we only have a little bit of the conversation between some of the legislatures. Some of them did think that intent to defraud helped create mens rea that helped limit the application of the statute. But I would submit that you don't really get there because of the way the nature of the statute works. It works by way of the homeowner who feels like they've been victimized writes a certified letter, and if it's not responded to, I don't know what happens then. It creates probable cause for a crime. I don't know. It's not clear there either. But if not responded to, law enforcement can make a decision to prosecute or go to the grand jury. And then it says a violation of subdivision B1A is an offense only if, and this is the part we contest, no substantial portion of the new home construction or home improvement services work. I guess I'm also sort of saying, as a procedural matter, when does the intent to defraud ever come up? When is there an investigation? What you have here is a homeowner creating a criminal statute out of what is normally considered to be a civil action, really, by writing a certified letter and not getting any response from a busy contractor who probably doesn't read his mail every day. He's out building houses. And I don't know what that does. I don't know what procedures a DA's office has, but we don't have that in the record. What we have in the record is a convoluted statute that uses a word that we know has been found unconstitutional in this state twice and other states for a variety of different reasons. And it's used here, and we know that, I believe we know, that it's obvious that we can't give the guidance to our clients, our contractors, to withstand the prosecution for this. Sure, if I have an expert that says 90% of the project's done, I'm probably going to win that trial, right? And if the state has an expert that says less than 10% is done, I'm probably going to lose that trial. But the vast majority of these cases are in the middle of that, including our case. And so we have no way to determine, no way to give the jury any guidance on what that word means. And it means a lot. You know, as just a simple exercise, Webster's defines the word about 9 or 10 different ways. So the man of ordinary intelligence would go to Webster's dictionary. Of or relating to substance is the number one definition, which makes no sense. Not illusory, having merit, having importance or significance. If you remember that Entertainment Resources, the word significant was also found to be unconstitutional. If he goes to a lawyer, the lawyer's going to tell him that the word substantial means, in Black's Law Dictionary, being significant or large or having substance. I mean, how is that guidance to the 5,000 contractors in Tennessee who are trying to obey the law, who are trying to do the work they're doing, who get this certified letter that says they want a refund, and they've got to figure out whether they've done a substantial portion. Some will know. Some will know that 3 days the project will be done, but most won't. We'd like this court, which has a panel from every division of the state here, to affirm the unconstitutionality of the statute, of this section, on its face, and let the legislature go fix the problem so the contractors can be guided and the defense attorneys can be guided and law enforcement can have the guidance to enforce this statute. Thank you, Your Honor.
Thank you, counsel. Mr. Groves.
A few things, Your Honors. First, I thought I heard my friend on the other side say that they did not concede that they had to bring an as-applied challenge first before bringing a facial challenge. Just direct the court to page 13 of their brief, which says, in challenging the constitutional vagueness of a statute that does not invoke First Amendment freedoms, defendants must first prove that the statute is vague as applied to their conduct. I read that as a concession. I also didn't hear very much of anything about their failure to successfully show an as-applied challenge. I heard a lot about substantial, a lot about the merits. I didn't hear a lot about the procedural argument, which is dispositive in this case. Turning to the merits on the standard, my friend seems to suggest that Johnson, even if it did not affect whether you have to bring an as-applied challenge first or not, that it still lowered the burden of proof. And on page 15 of the state's reply brief, we note several federal circuit court cases that have said that Johnson does not alter whether you have to bring an as-applied challenge first. That still remains good law. On substantial, Your Honors, The Tennessee Supreme Court did not declare the word substantial unconstitutional. The court held that a city ordinance, in that case, under the facts of that case, was unconstitutional. It involved a city ordinance saying it was a regulation about adult bookstores, and it had to do with the number of sexually explicit materials in the store. And obviously, in a case like that, where you're just tallying up the number of books in a store, it would be pretty easy to slap a label on that and have a specific number or a percentage. But it makes perfect sense for the General Assembly not to do that in a case like this, where you have a construction industry that's very diverse and can have all kinds of different types of projects. And it would be a lot harder to define a certain percentage of a construction project just based on what it was. You would have to measure that. I'm not even sure how you would measure that, actually, when you're talking about building a house versus building a swimming pool. I'm not sure how you would be able to compare the percentages. The 11th Circuit case that we cited in our brief, the reserve decision, it talks about how in the construction industry, the word substantial has this meaning that is flexible depending on the project. Regarding the notice to the Attorney General, I'll just reiterate, we haven't waived this issue. I'm not aware of any authority that would require the Attorney General's physical presence in a trial court proceeding to defend the constitutionality of a statute. Again, that's a rule of civil procedure. We're in a criminal context. The state AG's office is responsible for representing the state on appeal and defending the constitutionality of the statutes in this court. The defendant didn't assert waiver in their brief, so that's just not an issue that the court needs to address. Finally, the intent requirement, I also didn't hear a lot about that from my friend on the other side. They kind of just skirted past that, but I understand there's a genuine concern that some contractors might have about the word substantial in the statute. And we've heard a lot about contractors trying to obey the law. I understand that's a valid concern. The reason we have intent requirements, the reason we have mens rea requirements in the criminal law is to ensure that we are only punishing people with a criminal mental state. If you are trying to obey the law, if you are not trying to defraud someone, you are not violating the statute, regardless of how much of the project you have completed. It's throughout the defendant's pleadings in the trial court, they're talking about how this statute was designed to target the scammer contractor who shows up at your house, knocks on the door, asks for some money to repair your roof, and then absconds and goes away and gambles it all away at a casino. That was actually a case, State versus Hutchinson. It was brought under the theft statute, but that's a very clear example of how someone would have the intent to defraud you. This statute doesn't capture the contractor who's acting in good faith, who just has a business dispute with a client and they can't reach an agreement. Because we have the intent to defraud, that alleviates the vagueness concerns. Your Honors, I just want to emphasize that the trial court had a duty to presume this statute was constitutional. It did not do so. In fact, it skipped the as-applied vagueness challenge altogether and rushed to declaring the statute facially vague in all its applications. This court has a duty to uphold the constitutionality of the General Assembly's enactments. They receive a presumption of constitutionality because this is something that's been through the democratic process, and the people of Tennessee have decided that this is something that needs to be criminalized. If there's no questions, Your Honor.
Question.
Yes.
I don't know how to phrase it. So the state is basically arguing that substantial completion can mean a different thing as to every new home contractor and every person remodeling a house. Is that correct?
No, Your Honor. We're arguing that substantial is a flexible standard that is a perfectly valid term to use in any other context as well.
If it's only facially applied, then you're talking about to that particular person, correct?
Can you repeat the question? I didn't.
If we're talking about the statute as applied to that particular plaintiff, that particular plaintiff would have a substantial completion definition for that particular case based on what I guess the jury decides. And so it's different in every case.
In some sense, yes.
Well, how can a contractor building a new house or remodeling a structure know when to refund this money based on this statute?
So the common ordinary meaning of the word substantial means considerable in extent or value or amount.
Okay, so
And
what percentage of completion is that?
It's going to depend based on the nature of the project and the stage of the
Separate
project.
definition on each project for substantial completion.
And the stage of the project. I mean, the statute only comes into effect after 90 days, but if it's been 5 years, then maybe the term substantial is going to be closer to, completion. If it's only been 91 days, then, it might not be. It's going to depend on the circumstances of the case. And it was the defendant's burden, Your Honors, to produce a factual record. So whether the trial court gave the parties an opportunity, that should not be, the state shouldn't have to take the fall for that. And I believe that's in the defendant's own briefing in this case, that it's their burden to develop a factual record that shows they would be vague as applied on these facts.
All right, thank you.
If there's no further questions, we respectfully ask the court to reverse the trial court's order declaring the contractor fraud statute facially vague in all its
All right,
applications.
great. Thank you. Good arguments. Thank you, counsel. All right, need a break? You ready to go? Ready? All right. Would you call the next case, please?